Theories of punishment in Indian law include Deterrent Theory, Retributive Theory, Preventive Theory, and Reformative Theory. Deterrent Theory. 1. This theory is based on the idea that punishment should be swift, certain, and severe to deter people from committing crimes. 2. The goal of this theory is to prevent people from committing crimes in the future. And 3. Jeremy Bentham is considered the founder of this theory. Retributive Theory. This theory is based on the idea that punishment should be proportionate to the crime committed. It is also known as the eye for an eye theory. Reformative Theory. This theory is based on the idea that punishment should be used to reform the criminal, not just punish them. This theory involves teaching skills and educating the criminal. Preventive Theory. This is another theory of punishment. Modern Indian law. The Indian judiciary is guided by the Reformatory Theory of Punishment. The severity of punishment is proportional to the crime. The Reformative Theory of Punishment in India emphasizes the rehabilitation and reintegration of offenders as the primary goal of punishment, aiming to reform criminals and bring them back into society as law-abiding citizens through interventions that address the underlying causes of their criminal behavior, rather than solely focusing on retribution. This approach is particularly prominent in dealing with juvenile offenders and is guided by principles like individualization, non-punitiveness, and community participation. Key aspects of the reformative theory in India. 1. Focus on rehabilitation. The core idea is to reform the offender by providing them with opportunities for education, vocational training, counseling, and other programs designed to address the root causes of their criminal behavior, aiming to prevent future crimes. 2. Individualized treatment. The reformative theory recognizes that each offender has unique circumstances and needs, requiring a personalized approach to rehabilitation. 3. Non-punitive approach. Unlike retributive theories that focus on eye for an eye punishment, the reformative approach seeks to minimize harsh punishments and prioritize restorative justice methods. And 4. Community involvement. Integrating offenders back into society is considered crucial, often involving community service or support programs to facilitate reintegration. Application in Indian law. 1. Juvenile Justice Act. This act explicitly promotes the reformative theory by focusing on rehabilitation of juvenile offenders through measures like probation, counseling, and specialized care facilities. 2. Supreme Court rulings. The Indian Supreme Court has consistently emphasized the reformative approach in several cases, advocating for considering the offender's background and potential for rehabilitation when deciding on sentences. And 3. Open prisons. Some prisons in India are designed as open prisons, where offenders with good behavior can work and participate in community activities, facilitating reintegration. Criticisms of the reformative theory. 1. Effectiveness for hardened criminals. Critics argue that the reformative approach might not be effective for repeat offenders or individuals with severe criminal histories. 2. Potential for leniency. Some believe that prioritizing rehabilitation can lead to overly lenient sentences for serious crimes. And 3. Resource constraints. Implementing effective rehabilitation programs requires significant resources which might not be readily available in the Indian justice system. Overall, the reformative theory of punishment plays a significant role in the Indian criminal justice system, aiming to not only punish offenders but also to provide them with opportunities to become productive members of society by addressing the underlying causes of their criminal behavior.